Good morning, everybody. Sorry, running a little bit late. We have new digs over here that we're not used to. Um, I just want to welcome everybody. It's 9:05 to the start of the New Mexico Environmental Improvement Board meeting. And want to welcome everybody that's here in person and everybody that's online. Um, just to start the meeting, I want, like, Miss Jones, could you do a roll call to see who's present this morning?
Yes, I will do so. Member Bitzer, are you present?
I'm indeed.
Good morning. Member Ely,
Present.
Member Garcia,
Here.
Member Honker. I know he's online. Member Honker, can you hear us or unmute yourself? Maybe he stepped away. Chair Sweeney,
Present.
you have everyone here. Let me just, Member Honker, can you hear us and affirm that you're with us? Let me see if he's put something in the chat. He hasn't. I do see him online, Chair Sweeney. So with Mr. Honker, you have a quorum.
Thank you, Miss Jones. Appreciate it. With that, we'll go to our next agenda item, which is approval of October 24th, 2025 agenda. Is there any revisions or additions that our board members or our legal counsel see? If not, may I entertain a motion to approve?
I'll move
our
approval
agenda?
of the agenda.
Thank you, Member Bitzer.
I'll second.
Thank you, Member Garcia. Any further discussion now that we have a motion on the floor? No? All right. Ms. Jones, would you please do a roll call vote on Member Bitzer's motion and Member Garcia's second for approval of our agenda this morning?
Yes, Member Bitzer, your vote?
I'll vote yes.
Okay, Member Ely,
Yes.
Member Garcia,
Yes.
Member Honker? Okay, I saw his lips move. You said yes. You can unmute, you should be able to unmute yourself, Member Honker.
Yes, can you hear me?
Thank you. Chair Sweeney?
Yes.
Thank you. The motion passes.
Thank you so much, Ms. Jones. With that, we'll go to agenda item number 3, approval of September 2022, 2025 meeting minutes. And those were emailed out earlier prior to this meeting. Love to entertain a motion.
I move to approve the minutes from the September 22nd, 2025 meeting.
Thank you,
I'll
Member
second
Ely.
that.
Thank you, Member Bitzer, for your second. With that, is there any discussions in your review that needs any revision, fellow board members? No? All right. Ms. Jones, would you please do a roll call vote on Member Ely's motion to approve the September 22nd, 2025 meeting minutes?
I will. Member Bitzer, your vote?
I vote yes.
On the minutes. Okay, Member Ely,
Yes.
Member Garcia,
Yes.
Member Honker,
Yes.
Chair Sweeney.
Yes.
Motion passes.
Wonderful. Thank you so much, Ms. Jones. And with that, that takes us to agenda item number 4, which is public comment. Is there anybody in the room that would like to make public comment this morning? Thank you. Please come to the desk there and the mic. And this morning for public comment, as usual, we'll have public comment for 3 minutes as a limit. And then please just announce your name, and we welcome you this morning, and you look familiar. So thank you for coming.
Good morning, Madam Chair, members of the board. Good to see you this morning. I have a bit of a cold, so if my voice crackles a bit, that's why. I am here. I'm an attorney with the law firm of Gallagher and Kennedy, Dal Mullenberg. I think I said my name before, but perhaps not. And I'm here this morning on behalf of CropLife America. CropLife America is a trade organization that represents a number of companies, particularly manufacturers of pesticides and other agricultural chemicals. It's a heavily regulated industry at the federal level and the state level already. We have filed a written response in opposition to the petition that the board is going to be considering this morning. We've presented our arguments and position in writing. I'm happy to address that later, but I don't know if there's an opportunity to speak to that on the later agenda item. If you'd prefer, I can wait and do that, but wanted to bring that to your attention at this point.
Thank you so much. Legal counsel, should we wait or is this a good time?
Madam Chair, ultimately it's up to you, but I think it would make sense that you could consider it later on.
Okay, so if you would, we'll have some time for you after the petitioners present, and then you can also address the board.
Very good. Thank you, Madam Chair.
Thank you. With that, is there anybody else here in the room that would like to speak? If not, Ms. Jones, I think we have a number of hands raised on the platform. Would you help us kind of go through who would be up?
Yes, I'm gonna turn that over to Luis. He's been communicating with them. So Luis, if you would unmute and call on people who have indicated that they'd like to speak this morning. Thank you.
Yes, good morning, Madam Chair and members of the board. I'll call on Jean Harrington. Looks like you're already unmuted. If you would go ahead and speak.
And
Great,
please,
thank you.
And please share your name and who you represent. And much like I just shared, you'll have a 3-minute limit.
Yep. Good morning, Chair Sweeney and members of the Environmental Improvement Board. My name is Gene Harrington, and I am the Senior Director of State Affairs for the Animal Health Institute. I appreciate the opportunity to speak today to express concerns with the New Mexico Environment Department's petition to adopt rulemaking as adopted by House Bill 212, establishing the regulation of intentionally added PFAS in products, especially the section pertaining to labeling requirements. AHI represents manufacturers of animal biologics, diagnostics, medicines, pesticides, and feed additives used to maintain the health and productivity of livestock, service, and companion animals. As enacted, House Bill 212 contains an express exemption for veterinary health products from the legislation's ban on products containing intentionally added PFAS. This exemption first appears in Section 3 and is reiterated 4 additional times in that section. Animal health products also enjoy the exemptions provided for in Section 3 for medical devices and drugs regulated by the U.S. Food and Drug Administration and products regulated by or under the jurisdiction of the Federal Insecticide, Fungicide, and Rodenticide Act. Moreover, veterinary health products are explicitly exempt from the legislation's reporting requirements. All told, House Bill 212 exempts veterinary health products from the legislation's ban and reporting requirements at least 10 times. Despite the numerous express and other exemptions for animal health products, NMED is proposing to subject said products to labeling requirements that will go into effect on January 1st, 2027. NMED is acting under the authority granted it by Section 4, subsection B, that reads, "The board may adopt rules to carry out the provisions of the PFAS Protection Act, including requiring the labeling of products in English and Spanish." The use of the term may is a clear indication the labeling component of the proposed rulemaking is entirely discretionary. It is also important to note the phrase "adopt rules to carry out the provisions of the PFAS Protection Act" makes clear that any rulemaking pertaining to labeling consider the entirety or totality of the law. Given that roughly 5 to 6 pages of a 20-page bill are devoted to granting categorical exemptions to House Bill 212's most onerous provisions, the proposed labeling requirement is clearly inconsistent with the spirit of the legislation and the will of the legislature. Indeed, it seems unlikely that legislators would have invested so much time and energy to craft and approve exemptions for veterinary health and various other products from House Bill 212's most significant requirements, only to see the adoption through rulemaking of an unprecedentedly broad and burdensome PFAS labeling requirement, unlike that of any other state in the country. Another concern is that MED's proposed label falsely implies that all intentionally added PFAS substances are carcinogenic. This compelled misleading speech likely violates the First Amendment. For these and other reasons, AHI respectfully requests that the labeling section be stricken from the petition. Again, I appreciate the chance to comment. Thank you.
Thank you so much.
Yeah, thank you,
For
Mr.
your
Harrington. Next, I'd like to call on Patrick Moran. If you could unmute yourself, please.
Thank you. Good morning, Madam Chair and members of the board. I'm Patrick Moran. I'm an attorney for NFIB, the National Federation of Independent Business. We represent and support small businesses. We submitted written comments. I'm just going to give a brief overview of our opposition to the department's petition. So first, the labeling requirements are unlawful. The PFAS Protection Act exempts certain products from testing and reporting. And the testing and reporting requirements are really the basis of the law. When the department suspects that a product contains a PFAS, they test it, and if they're right, they issue a determination and require reporting, and if not, they issue a certificate of compliance. The product is all good to go. The rule flips this on its head. Under the rule, manufacturers are the ones who make a determination. This allows the department to say that they can label exempt products. But that makes no sense if that's the case. The law completely collapses on itself. The rule can't require labeling of products it has no authority to test. It can't even say definitively if the products contain PFAS. The second problem with the proposed rule is that the concurrently unavoidable use application procedure isn't authorized by the statute. So the PFAS Protection Act says that the board will make rules designated currently unavoidable uses of PFAS. The proposed rule instead requires an application that is so dense that small businesses will never be able to navigate it. It has 36 minimum application requirements. It requires detailed economic, scientific, and environmental analysis, thousands of dollars in fees just to apply, and the designation only lasts 3 years. This is not what the statute calls for. It's not a business's duty to make rules. It's the department and the board's job. And you can't force businesses to do all the heavy lifting. The law provides an easier and a free method of getting a CUU designated rule. It's called a petition for rulemaking. Third, the rule's presumption of intent goes way too far. So the statute defines intent as, quote, deliberately added or used in the manufacture of a product where the continued presence of PFAS is desired or expected in the final product. So that's a mens rea requirement. The rule, in contrary, defines intent as 100 ppm of fluorine. That's completely contradictory. And not only that, but it's an unfair presumption of wrongdoing. It shifts the burden to businesses. It's not fair, and it's not what the PFAS Protection Act calls for. So thank you for your time, and I ask that you protect small businesses from the proposed rule. Thank you.
Thank you for your comment. Luis?
Yeah, thank you, Mr. Moran. Next, we call on Tim Shystak. Sorry if I'm pronouncing that incorrectly. Please correct me.
Good morning, Madam Chair, members of the Environmental Board Committee. My name is Environmental Board. My name is Tim Shestak with the American Chemistry Council. Thank you for the opportunity to provide comments today. Just by way of background, ACC is a national trade association of companies that manufacture vital chemistries for a variety of uses, strengthening national defense, increasing energy development, manufacturing computer chips, automobiles, and supporting healthcare and biotechnology. We were extensively involved with the department, legislators, and others as House Bill 212 was making its way through the legislative process. And earlier this week, we did file written comments with the board, raising several issues and concerns with the draft regulations that are being proposed. Consistent with some of the prior commenters, in our view, the draft regulations are inconsistent with the intent of the statute, given the multitude of specific product categories that are entirely exempt from the most substantive provisions of the law, including the currently unavoidable use provision and the reporting requirement, but yet still would be subject to a labeling requirement. As we noted in our written comments, the statute does include a phrase, quote, adopt rules to carry out the provisions of the Per and Polyfluoroalkyl Substances Protection Act. implying that the totality of the statute must be considered when proposing implementing rules, including labeling. And unfortunately, we believe the draft rules do not meet the standard and exceed the overall intent of the legislature. Also, as you heard previously, the rules, in our view, appear to conflict with various federal laws, including those that govern pesticides, fertilizers, and other related products. The federal law includes a uniformity provision that states cannot impose or continue in effect any requirements for labeling or packaging in addition to or different from those required by US EPA. This is particularly important given the draft label concepts that have been made public propose a warning that could differ from EPA required health warnings. Some of our member companies have also raised questions about how this proposed labeling requirement would intersect with recent changes to the Federal Occupational Safety and Health Administration's hazard communication standards requirements. And then finally, the proposed labeling requirements, as you heard previously, may also violate First Amendment rights against compelled speech by imposing counterfactual and controversial information on product labels. The statement that was circulated and related to draft label concept says, quote, "This product is made with PFAS or contains component parts made with PFAS. PFAS are a family of chemicals, exposure to which are associated with negative health and environmental effects." This statement is not true for all PFAS. For example, fluoropolymers, a class of PFAS, have been found to be substances of low concern for human health and the environment. Therefore, the proposal to mandate a statement about all PFAS is not accurate and goes beyond purely factual and non-controversial information. Given these significant concerns and potential legal issues associated with the draft rules, we respectfully request that the EIB not approve today's petition and instead direct the department to move forward with a revised proposed rule that addresses the issues that have been identified. Thank you again for the opportunity to comment.
Thank you. Apologize, it's been 3 minutes, but appreciate your comment. Luis, do we have anybody else on the platform wanting to make a public statement?
Madam Chair, I don't believe we do. I've sent multiple messages in the chat asking people to raise their digital hand, and I don't see any others.
Thank you, Mr. Lopez. Appreciated that. And it sounds like with that, we're beyond, or we've completed agenda item number 4, which is public comment, and we'll move on to agenda item number 5, which is EIB 25-61R in the matter of proposed adoption of 20.13.2 NMAC. And with that, we have NMED Council. So please come up to the front, and looking forward to hear your presentation this morning.
Good morning, Madam Chair and members of the board. My name is Greg Smith here. I'm Assistant General Counsel for the New Mexico Environment Department, and I'm here on behalf of the petitioner, NMED's Office of Strategic Initiatives. I'm joined here today by Dr. Eric Chapman, who is the Science Coordinator in OSI. I'm also joined here today by Christina Keys, who is the Acting Director of the Office of Strategic Initiatives. We are here today to respectfully request that the board adopt a new proposed rule at 20.13.2 titled the Per and Polyfluoroalkyl Substances in Consumer Products. To provide some context for this request, I want to provide a brief background of the PFAS Protection Act, which was passed by the New Mexico legislature earlier this year and signed into law by Governor Michelle Lujan Grisham on April 8th, 2025. The PFAS Protection Act is codified in Section 74-15-1 through 74-15-7 NMSA, and the Act prohibits the sale of certain consumer products containing intentionally added PFAS. The product prohibitions go into effect in 3 phases. The first phase, which goes into effect on January 1, 2027, prohibits the sale of products containing intentionally added PFAS, such as cookware, food packaging, dental floss, juvenile products, and firefighting foam. The second phase goes into effect January 1, 2028, and prohibits the sale of additional products containing intentionally added PFAS, such as carpets, cleaning products, cosmetics, among others. The final phase goes into effect on January 1, 2032, and at that time, any products containing intentionally added PFAS that are not exempt will no longer allowed to be sold in New Mexico. In addition to these prohibitions, the PFAS Protection Act requires that the Environmental Improvement Board adopt rules that detail the information that a manufacturer of products containing intentionally added PFAS must report to NMED. The board must also adopt rules to exempt products from statutory reporting requirements if those products are already exempt from the prohibitions I just listed. The board must also adopt rules creating a series of ranges of the amount of PFAS in a product for reporting purposes unless they're exempt. And the board must adopt rules to identify the currently unavoidable uses of PFAS that are essential for health, safety, or the function of society, and for which there are no reasonably available alternatives. The PFAS Protection Act authorizes the board to adopt rules to carry out the provisions of the act, including requiring the labeling of products in English and Spanish. It also authorizes the board to adopt rules to determine that a product containing intentionally added PFAS, as determined by other states, can be used in the state of New Mexico. The PFAS Protection Act also contains enforcement and penalties provisions for violations of the act and rules adopted pursuant to the act. In accordance with the mandate of the legislature, NMED drafted a proposed rule which implements the aspects of the PFAS Protection Act that I just outlined. The draft rule is attached as Exhibit B to the department's petition, and it includes provisions covering prohibitions, exemptions, currently unavoidable uses, reporting requirements, labeling, testing, fees, penalties, and enforcement. In addition, the department has provided a statement of reasons to support the adoption of 20.13.2, which is attached as Exhibit A to its petition. NMED engaged with stakeholders prior to this meeting and plans to continue to engage with stakeholders in advance of any hearing. The PFAS Protection Act contains 16 enumerated exemptions from the prohibition on the sale of consumer products containing intentionally added PFAS. The exemptions include medical devices and drugs, motor vehicles, semiconductors, non-consumer electronics, some refrigerants, and products containing fluoropolymers, among others. These enumerated exemptions were not a part of the original draft of the Act and were included as a result of stakeholder input and engagement during the legislative process. In addition, prior to this meeting, NMED has established a dedicated NMED PFAS email address where stakeholders can request meetings with NMED staff and ask questions about the draft rule. NMED has fielded and responded to dozens of industry stakeholder emails and has scheduled or held a total of 8 meetings with interested stakeholders so far. NMED held an industry stakeholder webinar with over 200 registrants on September 25, 2025. On the same day, the Smart Comment portal was opened so that interested parties could begin to provide public comment. NMED held a webinar for the general public on October 22nd, 2025, which included 384 registrants, 257 of whom attended. NMED currently plans to continue to meet with stakeholders in advance of any hearing if a hearing is scheduled, and it plans to have an IT reporting system meeting to invite stakeholders to provide feedback on the functionality of a future reporting system. The board is authorized to adopt regulations regarding intentionally added PFAS in consumer products pursuant to the Environmental Improvement Act and the PFAS Protection Act, as well as 20.1.1 of the NMAC. Because of that, the department respectfully requests that the board authorize a hearing to occur before March 13, 2026 to consider the merits of this petition. We anticipate needing 5 days for the hearing. The department also requests that if the board authorizes a hearing, it appoint a hearing officer. We appreciate the board considering the department's request, and I'm happy to answer any questions.
Thank you so much. Fellow board members, do you have any questions? Yes, Member Ely?
Thank you, Chair Sweeney. So could you please explain why the March 13th, 2026 deadline to have a hearing?
Certainly. So the first round of prohibitions go into effect on January 1, 2027, and we need to develop the CUU process and have a rule in place, the currently unavoidable use process, in advance of that first ban. And so we're asking for a March date. So we hope to pass a rule in the summer so that we can begin taking CUU applications before any ban would go into place on products containing intentionally added PFAS.
Thank you, Member Ely. Yes, Member Garcia.
Did you say that you all consulted with the Department of Agriculture?
I did not.
Okay, thanks.
Thank you, Member Garcia. Any other board members have any questions? With that, I do have a couple of questions. You shared that there was initial outreach and engagement. What kind of, can you just maybe elaborate a little bit more? Did you meet with potential entities that will be affected by the rule? And then in doing that, did they provide comments or feedback? And then how did the department include that in the development of the rule?
Thank you, Chair Swain and members of the board. So the beginning of the stakeholder input began, this was an agency sponsored bill, and it began during the legislative process. So we met with stakeholders, Secretary Kenney met with stakeholders and various industries as represented by the 16 enumerated exemptions that are contained in the bill. So that was the first step of stakeholder engagement that went on. We held a stakeholder webinar in September of 2025, and at the same time opened up an NMED email address and began receiving questions as well as requests for meetings with stakeholders. And we've been responding to those emails as well as meeting with stakeholders and are considering incorporating their feedback as we move forward.
Thank you for that. And I think what was the date? Had there been a draft rule kind of being shared with stakeholders, or is this the first time during this petition that the draft rule was shared publicly?
So when the stakeholder meeting occurred in September, we had not shared the formal draft rule yet. It was a detailed webinar where we explained, what we intended to do with the draft rule, but a draft rule was not shared until October 8th.
Okay. And Luis, I see somebody has their hand raised. Could you identify who that is?
Yes, Madam Chair, that is Bruce Weatherby. He's entered an appearance in this PFAS matter as an interested party.
That's correct. Yes, Mr. Weatherby, do you have something to share with the board at this point?
Yes, Madam Chair, and thank you to all of the members of the board. I'm assuming you can hear me okay.
Yes, we can.
Thank you. I want to thank you. I also want to thank the department for bringing this. I think it's an important issue to be addressed. I'm mostly concerned about the process, and as it moves forward, that there be one of the things I've noticed is that there's a heavy reliance on staff at MED and a hearing officer, and calendars are getting crowded. And all of you that sit on boards such as the EIB or the Water Quality Control Commission have your own schedules as well. So this is just a suggestion and a concern. This is very important. It's important that it be addressed soon. I believe that the board and the department look at the potential of, despite the very fine work, and this is not a criticism at all of hearing officer Orth and other matters, but I think the support staff needs help and may be, I know Secretary Kenney mentioned at another meeting that they only have one hearing officer, and I think it would be helpful to advocate for such a change and that there be a really good record kept of these proceedings. So that's all I have to offer at this point.
Thank you, Mr. Weatherby. And then I know, I think, did you have anything more to add on this matter? I know, you had said some words during public comment, but I just want to make sure that you have time to speak.
Madam Chair, members of the board, as I mentioned during the public comment period, on behalf of CropLife America, Gallagher and Kennedy has filed a written response in opposition to the petition. I don't have too much to say in addition to what's in there. And you've heard some other points in the public comment that relate to some of the things that we have in our written petition. But if you might give me a few moments just to comment a little bit on the department's presentation and the petition. CropLife America's chief concern relates to the extensive regulation of pesticides in particular and other chemicals at the federal level, and the potential for considerable conflicts with this rule and existing regulation under the federal laws and other state programs. As it relates to the board's consideration of the petition and setting a hearing, as has been mentioned earlier, the labeling requirements, although they're only part of the concerns of our clients, are not a mandatory requirement of these rules. And as I think you've heard during public comment and in our petition, they're a part of the proposed rule that has raised very strong concerns under a number of by a number of folks. So one of the options we point out in the written response is that while we recognize that there are perhaps pieces of the proposed rule and the process that have some time sensitivity, because the labeling requirements are discretionary in terms of the board adopting a rule, there isn't any deadline or anything else. One option that the board, we believe, could take is to not include the labeling piece in a hearing if the board goes ahead and decides to set a hearing at this time. As to the rest of the rule, you've heard some comments, and I think the board has had some questions that raise concerns about the level of stakeholder involvement. There's been very little time, and it sounds like what the department is proposing here is a stakeholder engagement process between now and the hearing. And I think one of the implications of that is that this rule really isn't ready to go. Another aspect of our written filing relates to a requirement of the State Rules Act that agencies have to make technical information supporting a rule publicly available by the time a rule is public noticed. And as I think you've heard, this is going to be a very highly technical rule. If you decide to consider the whole thing, I would also add, I don't think a 5-day hearing time is realistic. But for members of the regulated community and the rest of the public to meaningfully comment on a rule and prepare for hearing, the technical information that's supporting a rule really is vital. And that hasn't been made available yet. So those are the central points we would like the board to consider in determining whether it wants to go ahead with a hearing at this point, or whether it wants to postpone that decision to allow for additional stakeholder involvement in advance, or perhaps the board wants to consider setting a hearing, but paring down the scope of at least the initial hearing on this rule. Thank you very much.
Thank you for your comment. And I see Mr. Weatherby's hand up again. Mr. Weatherby, did you want to add any more?
Thank you very much, Madam Chairwoman. I did want to add this. I think I understand the previous speaker's concern about having an appropriate amount of time to deal with this. And while I agree with that, we may be on different sides of the issue itself. I do think it's important, again, this kind of, that people have waited a long time to address these issues, and the public has a very keen interest in this. Our reporting and interviews with people see this as an issue that needs to be addressed. And that's why I mentioned trying to firm up the support and the staff that you all may need to conduct such a hearing. But I think slowing it down isn't necessarily the answer, as much as maybe extending some time, but certainly not taking it and postponing it any serious amount of time when some of that could be addressed by just increasing resources to entertain any stakeholder meetings and things of that nature, and the schedules that your board and your support staff have to meet. Thanks.
Thank you, Mr. Weatherby. Fellow board members, does that discussion spur any other questions that you might have or discussion? Yes, Member Garcia.
Yes, one more question for Mr. Smithgear. You said you did not consult with the Department of Agriculture. Could you tell me why you did not?
Thank you, Madam Chair and Member Garcia. We did not feel that we were required to consult with them for this particular rulemaking, and that's why we didn't reach out affirmatively. We would certainly consult with them if they reach out to us.
Does the Act not require that you consult with them?
The Act requires that we consult with them only in instances where we are creating new bans, essentially, beyond what the bill calls for. And the rules as written, we're not creating any new bans outside of what the statute already prohibits.
And since you haven't had real stakeholder meetings, taking comments, considering amending your proposal, etc., before the petition, which is often done by your department, would you be considering amending the rule before a hearing?
Thank you for the question. Yes, we would.
Okay, thank you.
Any other board members have any more discussion or question? Yes, Member Ely.
Just a little discussion, and I don't know if I need to move have a motion first, but it seems like we do need to have a hearing sometime next year, not this year. Our calendar is full, and we would have to wait until after the legislative session, which is normal, and it concludes about February 19th. That would leave about a month window between the end of the session and what you're proposing as a kind of a deadline to finish the hearing of March 13th. I agree with Mr. Mullenberg. 5 days doesn't seem like inadequate enough time, and it's a little, I think, preferred to make it a little longer than you anticipate, so we don't have to reschedule for more time to hear all the testimony. I do think we should hold a hearing next year, in part because of the upcoming deadline of January 2027, and to try to get some things in place prior to that so industry understands what they need to do in order to comply, and the public understands what's coming. So I would propose that we do move ahead with a hearing. I appreciate Mr. Mullenberg's comments about the labeling, and potentially, we could pull that out during the hearing, or during deliberations after the hearing. So it might be nice to think about how that might work, depending on what it looks like. So right now, we're not making any decisions about the rule and what it looks like. We're just establishing a process to do that. And it could be modifications to whatever the board brings forward based on what we hear during the hearing. So those are my comments.
Thank you, Member Ely. I agree with that scheduling that you outlined in some of the constraints. So we will be looking at the end of February, early March. How does fellow board members' schedules look like? I see Member Bitzer is open.
Wide open.
Thank you. Member Ely?
I'm open at this time too. Of course, the hearing officer's availability is crucial.
Yes. Ms. Jones, do you know our hearing officer schedule? If our hearing officer has availability during that time frame? Okay. With that, I think we could we yes, legal counsel?
Madam Chair, just a suggestion that we may want to ask the department if they would like to respond to Mr. Mullenberger's comments, or any of his comments.
Thank you. Yes.
I mean, specifically, because I think there was one comment about the scientific data being available.
Yes. Would you mind responding?
Of course. We have not public noticed the comment yet, or the hearing yet. We have not gotten a hearing date, but we will follow the State Rules Act when we do that.
Thank you for that. Thank you for that. So since we don't have a critical piece of information with our hearing officer availability, is it possible, NMED, that we hear this petition and make a decision at a subsequent meeting when we have that information? Or what your thoughts are? Yes.
One suggestion is that the board can consider assigning a hearing officer and granting the petition, and then delegating the specific scheduling to the hearing officer, which would happen after this meeting.
Okay.
Coordinating with the hearing officer schedule, your schedules, and then the party schedule.
Thank you for that. Board members, does that sound amenable to you? Yes. All right. I do see Mr. Weatherby's hand up again. Mr. Weatherby?
Woman. I understand the issue relative to the availability of a hearing officer. Is there any reason that there is only one hearing officer or I guess a better question, is there any reason there couldn't be a second hearing officer? I realize I really respect the work that hearing officer Orth does. I think she has always, from what I've seen, run really good hearings and very fair to people. But I also know that there's a certain workload. These are important issues that affect the public, affect obviously interests of industry, agriculture, and the general public, and not to have a sufficient number of staff people, or in this case, a hearing officer that is an alternative to have a backup person or someone else who could be appointed seems to be not a good reason to postpone something. So I would just offer that at this point. If somebody knows that if there's anything that says it can only be one, then I understand that, but I don't understand that that would be, it shouldn't be a problem.
Mr. Weatherby, this is the board counsel with the Department of Justice. My understanding is that that's a Department of Environmental Department matter, and at this point, they have one hearing officer available.
Thank you for that, legal counsel. And I think what we had discussed or what you had shared a few minutes ago, where we vote on the setting a hearing, and then we can also, in the past, we've done this where we've allowed the chair, myself, to work with a hearing officer to set the details.
That's correct.
Yes. So if the board would like to consider that, that would be great. Mr. Weatherby, sorry, I haven't been looking up here. Do you have your hand up again? Oh, thank you. Appreciate that, Mr. Weatherby. So fellow board members, would you, anybody like to propose a motion?
We're gonna miss Bill Honker. He's the one that always proposes the motions. Okay. So I move that we set a hearing for EIB 25-61 in the matter of proposed adoption of 20.13.2 NMAC per and polyfluoroalkyl substances in consumer products, and that the board chair work with the hearing officer to establish a hearing date after February 19th, 2026.
I'll second that.
Thank you, Member Ely, and Member Bitzer for your second. I just want to check with our legal counsel. Does that sound like a sound legal motion?
Yes, Madam Chair.
Thank you so much. With no further discussion, Ms. Jones, would you please do oh yes.
We didn't set the number of days. The department had suggested 5. I do think we need more than that. I don't know, 8 or 10 days.
And we can also work with the hearing officer for that detail.
Okay, sounds good.
Thank you. Ms. Jones, would you please do a roll call vote on Member Ely's motion?
I will. Member Bitzer, how do you vote?
I vote yes.
And Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
I am going to abstain as this matter will likely exceed my service on the board. So,
Thank you for that. Chair Sweeney, your vote?
Yes.
The motion passes.
Thank you, Ms. Jones, and thank you, board, and thank you for coming this morning for the petitioner's staff, and also, as well as the others that have contributed to the discussion this morning. With that, if there's nothing else, yeah, we're good on agenda item number 5 this morning.
Thank you, Madam Chair, members of the board.
Thank you. With that, we go to agenda item number 6, our next meeting and older business. Yes, Member Hunker.
I just had a question. I had a note on my calendar regarding an OSHA hearing the week of November 3rd. I just wanted to confirm we've rescheduled that and it's not happening that week.
That is correct, Member Hunker.
Okay, thank you.
And the date for that is in January, 1st or 2nd week in January.
Ms. Jones, you probably have it quicker than I can scroll.
That's what I have.
Um,
Sorry about the heat rule?
yes.
Yes. Correct.
Wonderful. With that, wait, give me 1 minute. So under the old business item, was today we were supposed to discuss the regional haze, deliberation. Sorry, I had a brain freeze there. And so we were discussing, alternative dates for the regional haze, deliberations. And I believe we are looking at the end of our CTFP week, our November, pull this up, 21st. So that would be that Friday at the end of that CTFP. And I want to share that with fellow board members and see what your schedules look like. And if, because we were already scheduled for the CTFP, and it looks like talking with the hearing officer that she thought that we would have time that Friday to do that. And I just want to check with the fellow board members if that would be amenable. And any questions? Yes, I see a thumbs up from Member Hunker. And Member Garcia said yes. And Member Ely says yes. Member Bitzer, thumbs up. Wonderful. So we will reschedule our deliberations that were scheduled for today for the regional haze to November 21st. And with that, I think, is there any more questions about scheduling? So the other follow-up scheduling is the potential for the CTFP deliberations after the hearing closes the week of November 17th. We were looking at the December 8th. And I know Member Garcia, Ms. Jones did share that she had reached out to you and you have a schedule conflict possibly. Okay, so if we started at what time in the afternoon? 1 o'clock. Would that work for the other board members? So December 8th at 1 o'clock. And any questions or discussions about that? Okay, Member Ely said that works for her. And that works for Member Garcia and Member Bitzer, thumbs up. And I mean, Member Hunker and then Member Bitzer. I know you keep going on frozen. Can you mute yourself? I just want to make sure it's also good for your schedule. It's good for my schedule as well. He's frozen again. You're frozen. Yes, can you put it in the chat? There you are. You're unfrozen, Member Bitzer. We can see you now. Yes. Yes, you are good. So December 8th at 1 p.m. for the deliberations for the CTFP. Is there any other discussions on the scheduling of those two reschedules? Yes, Mr. Mullenberg.
Madam Chair, I just am a little puzzled by the scheduling on CTFP deliberations. The hearing officer announced that there would be a period for post-hearing closing arguments, and I think in the order it indicates that the written closing arguments will be due 30 days after the record is available. So I'm thinking that that date would probably be a little earlier for deliberations. Maybe you have something else in mind, but I just wanted to mention that.
Thank you, Mr. Mullenberg. And I also see Ms. Sona on the platform. Ms. Sona.
Good morning.
Good morning, Ms. Sona. The floor is yours. Ms. Sona, we can't hear you. I don't know if it's your mic. We heard your first good morning and then we didn't hear anything else.
She's put in the chat that she has no objection to the date.
Thank you, Ms. Sona. No objection to the date. And then legal counsel, I just want to make sure we have all the details. I know we're managing a lot of details on all of our hearings, but the detail that Mr. Mullenberg brought up about the procedure for the closing. Do you have any comments on that?
Yes, it's Madam Chair. My understanding is that the proposal or the suggestion to do the deliberations on December 8th were dependent on a few things. And then in the event those things happen, there's a lot of things that have to happen in order for that to take place. The hearing officer would be in touch. And in the event there has to be some sort of modification, as we've done with the first 2 weeks, we're just trying to figure out what we can do and fit.
Thank you for that, legal counsel. So maybe if I have a follow-up question for you, would it be possible, are we in good standing if we do schedule it for December 8th afternoon?
Well, we have some time before the formal notice that we'd have to make for that, which is what we're waiting for the dominoes to fall in place.
Thank you. Thank you so much. Yes, yes, please. And please come up to the speaker or the mics up here so those on the platform can hear you.
Thank you, Madam Chair. I appreciate the opportunity. My name is Stan Harris. I represent HF Sinclair in the hearing that we're discussing right now, and I just wanted to echo the concerns that Mr. Mullenberg had. It is also our understanding that the parties were to have 30 days from the date of the availability of the transcript to provide a final closing, and I'm unsure that this schedule for December 8th would accommodate. Just wanted to make sure that I had made that record clear as well. Thank you.
Thank you for your comment. And I also see Mr. Weatherby up on the platform. Mr. Weatherby?
Thank you again, Madam Chairwoman. I don't have a particular concern, at least at this point, about the December date. I think your counsel has given some options there. But what I am concerned about is that the transcript became available in the last day or so, I believe. And as I understand it, it's available for someone to apparently purchase from the court reporter or the company that provided the transcription. It is a public record, and I understand that there's an availability of the public record being seen by making an appointment. And it seems to me that that record ought to be published or made available. I'm certain that the IPRA statute would provide a way to get it, but it is a public record and it should be available electronically. But having members of the public have to purchase it seems to be not necessarily the best way to go about this. And I think it would be really important. I know on other matters, some of the transcripts have been made available. If you look at the Water Quality Control Commission's hearings on the original produced water regulations, they posted the hearings in, I believe it was the August 2024 hearings. on that matter. They posted the transcript. So I would just ask that they be made available for the public as soon as possible in a manner that makes it easy. They shouldn't have to go out and pay for it. Thank you.
Thank you, Mr. Weatherby, for your comment. Ms. Sona.
Are you able?
We heard your first word and then it went out. Mr. Weatherby, did you have more to say? I see your hand still up.
No, I'm sorry. I forgot to put it down. I'm getting old. Thank you.
Thank you, Mr. Weatherby. Okay. I saw the comment briefly. Ms. Jones? Yes, could you read it? Because it popped up and then it went away.
Ms. Sona's comment is NMED objects to addressing non-scheduling matters in this meeting.
Thank you for that, Ms. Sona. And then I think we're done with the discussion. I think we were just talking about the scheduling. So appreciate everybody's comments this morning. Do you have anything more to add, Ms. Sona? I see your hand still up. Thank you, Ms. Sona. All right. With that, I do want to look to legal counsel for some other discussion and news. So, Mr. Legal Counsel.
Thank you, Madam Chair. And this is just to share with the board and others that Vice Chair Amanda Trujillo submitted her resignation effective immediately earlier this week. And so she's no longer on the board.
Thank you so much. And so if you can imagine, we're trying to make sure we keep our schedule going, and there is a lot of work before the board, and there's already been a lot of work done. So we, as our legal counsels shared, we want to keep this moving. So I appreciate everybody's attention and everybody's work. And we look forward to additional interaction here in the next few weeks. Thank you all for coming. Yes.
We need a motion. I
We
would
need
make a motion to adjourn.
Thank you, Member Honker.
I'll second that.
Thank you. With that, Ms. Jones, can you please do a roll call vote?
I can. Mr. Bitzer, Member Bitzer, your vote to
I
adjourn.
vote yes.
And Member Ely?
Yes.
And Member Garcia?
Yes.
And Member Honker?
Yes.
And Chair Sweeney.
Yes.
Adjourn.
Thank you all.